Hello, George.
Good morning, Ansan.
Can you tell us a little bit about security for legal costs in London maritime arbitration?
Yes, of course, Ansan. Here, we're looking at security for legal costs, not security for the claim. Ordering security for the claim is outside of the jurisdiction of London maritime arbitrators. They cannot order the arrest of a vessel or of a bank account, for example, but they can order that the claimant puts up security for the legal costs of the defending respondent. This may seem rather odd when we're all used to the idea of the claimant obtaining security rather than giving security. Here, the security is therefore awarded in favour of the respondent. The concept of security for costs comes from the English legal court system. As you know, in London, a winning party can recover their legal costs. Not every arbitration centre allows this. It's one of the major differences between London and New York, for example. Even if you win in New York, you don't usually recover your legal costs. There are policy arguments for and against the recovery of costs, and I don't need to cover them now. So what criteria are applied to get an order for security for costs? The concern is that if a claimant loses their claim and costs are awarded against them, then the respondent may be unable to recover the costs of successfully defending. It used to be that to get security, all the respondent needed to show was that the claimant was resident outside of the UK, but this is no longer the test. What the respondent has to show is a strong reason or reasons why the claimant might be unlikely to pay a costs order. For example, it's a shell company or appears to have no assets. You can see that this becomes a potent weapon in the hands of a respondent, and it can be used to stifle a claim. This would be totally wrong, especially where it's the respondent's behavior which has put the claimant in an impecunious position. So arbitrators have to assess the application for security for costs carefully. The LMAA terms provide that an application for security for costs cannot be made until after the service of a defence. This gives the tribunal the chance to weigh up whether it is right in all the circumstances to order the security. It is not usual to consider the merits, but the stronger the claim appears, the less likely it is that security will be ordered. Assuming the respondent is entitled to security, it also has to provide a breakdown of their anticipated costs, and the tribunal will examine this closely. If an order is given to provide security, the form of security can be by bank guarantee, but an escrow deposit, a solicitor's undertaking, or a P&I club guarantee are equally common.
Thank you so much, George. See you at the next episode.
Okay, I look forward to it. Bye-bye.
Bye bye.